That's the prosecutor's closing statement in the Jessica Chambers case. I have Gene Rossi with me. Gene, I'm think it was you, but I'm just curious, just as a stylistic thing, with this prosecutor just loves to fold his arms in front of the jury and have a pen in his hand. I mean, it's just kind of a weird style. Just give me a couple seconds. Does that strike you? I know it doesn't make a huge difference.
I used to, as you mentioned in earlier segments, I trained about 1,000 prosecutors, and we had lectures on how to use your hands and how to stand and how to use your voice. And I've been hard on him, so I'm going to be a little easy today. But crossing the arms and holding the pen and moving around without any purpose, I wouldn't recommend that for any new prosecutor or seasoned prosecutor.
No,
I just wouldn't do it.
Yeah, I mean, I don't know. It kind of like has almost like he's having a difficult time believing his own story, trying to get around that Derek Eric stuff. I think he should be more emotive and more powerful in that denial.
Listen, Bob, can I make a comment, though? I was shocked that he mentioned in my opening, members of the jury, I purposely gave you a clean slate so that you would draw your conclusions by the testimony. Hey, Bob, you and I have observed and done many openings. There is no way I'm going to give a jury a clean slate in my opening. I, in fact, tell people that my opening is really my closing with variations. But by the time you end your opening, you want that jury to have a mosaic in their head about what that trial is about. And when I hear the phrase clean slate, you're kidding me.
Well, I'd love to get into the nuances of the opening because a lot of lawyers tend to be very fragile in the opening and very, laid back. But I do a summation. And I just round it off with that's what the evidence is expected to show. So people have often laughed at me. They're like, did you just give a summation or an opening? But I want that jury walking away. And the opening is the most critical part of the case because it lays the roadmap out. Minds start getting set. And you want to really get out of that gate, especially as a prosecutor. Real quick before we go to another clip, Gene, just trial tactic wise, we have HJ1 Mad City in the chat room and asking a question. We're going to take a couple of variations on this theme, but the answer is if it's a mistrial, go to Louisiana. There's an open charge in Louisiana for murder. You have any thoughts on that? If you can't get this conviction here, go elsewhere and then circle back.
I respectfully disagree with it. If it's 11-1 for guilt, I would give it one more chance at a conviction. I'd have a trial in, say, 3 months. But you got the whole problem with Stanley Liggins in Iowa. By the time you try it the third time, the jury's going to find out that this is the third time and that there's key part problems with the case. I would retry it one more time. If you can't get a guilty on the third retrial, then go to Louisiana. Even if you get guilty, they'll probably try him in Louisiana. I do one more time.
Well, thankfully, I've never had a murder case that ever ended up in anything other than a guilty verdict. But if I were in this scenario, I would kind of go to Louisiana and just kind of toy around a little bit. Like, what's your evidence look like? How solid a case is it? Because this is going to be a circumstantial case no matter how you look at it. And I may make a decision, go there, get a conviction, hopefully come back, and we'll get a plea on this case at least and try to wrap the whole thing up. And again, it really depends on the nuances of the case in the other states and comparing them amongst prosecutors' office. Gene Rossi, always great commentary, but we heard the prosecution's closing statement. Let's listen to how the defense positioned this in the defense closing. You're in the Jessica Chambers case. We'll be back on the other end with Gene after the defense opening. Okay, that's a defense attorney and part of her closing statement. I have Gene Rossi with me. Gene, I personally think this defense lawyer has done an amazing job. I love her cadence in the courtroom. She's very logical, very respectful of Jessica, and she is bringing out, let's start with two pieces that I've noted. She brings out the fact that they do this interview of him after they already did 2 previous interviews that weren't recorded. In today's day and age, that just shouldn't be going on, and I don't think spells well for the prosecution. Thoughts?
Absolutely. I worked a lot with the FBI agents, and if they had an opportunity to record an interview, especially of a murder suspect, they would put that recording on the minute they talked to him, because now, in today's day and age, jurors are very skeptical of reports that aren't shown to the defendant. It's their variation. I did want to say this about Darla Palmer. She is doing all the things that I taught new young lawyers and seasoned lawyers. in your opening, under promise, overperform, and in your closing, tell the jury, hey, I told you in opening A, B, and C, and we essentially proved it, even though we don't have the burden of proof. But the other thing she's doing is she's making lemonade out of lemons. His inability to recall exact details and his some of the statements that he pulled back from, she's basically trying to mitigate it, and she's doing the best job she could. But the last point I want to make is she hammered the prosecution on the whole Eric thing. You know, she walked, she talked, she spoke, she said her name, and she did a really good job. And of course, her demeanor is incredibly believable.
Okay, I want to go back to a point I was going to bring out. But how she tied the fact that they didn't do the first two interviews, then record them, and then all of a sudden they're being recorded, and now he's scratching his head kind of thinking, trying to, make up stuff as he's going along. And I think jurors can understand that when this kind of technique, she called it quote-unquote law enforcement technique with a little bit of a grin, and they're lying to him, that this, not having the two previous interviews and then lying to the guy could cause anybody under those circumstances to begin to not speak correctly or even lie, because they know that they're in the stern because the cops are essentially saying, we think it's you.
And the other thing is this, I think Quentin Tellis only has like an 8th grade education. I could be wrong on that, but he didn't go to Harvard Law School, let's put it this way, or Yale undergrad. And you got two officers that are, not taking advantage of Quentin Tellis, but they know that he's not the sharpest tool in the drawer. All right.
Right.
So,
and you know what? Obviously, I'm sorry to cut you off, Gene. There's a level of distrust in this community because, as Kathy Russian, who's out there, says, you have the African-American community essentially behind the defense side and white folks on the other side. So obviously there's racial division, which spells to me distrust of the police department. So listen, guys, you're at the Law and Crime Network, Jessica Chambers case, and we are going to be back in a moment. Jessica Chambers case, prosecutor's rebuttal closing. Gene Rossi's trained 1,000 trial attorneys. I've trained probably just about as many myself. And Gene Rossi, I'm going to again be quiet and get into my Zen mode. I just want to bring out 3 points. Everybody relax. Everybody Zen. Everybody be happy. The didn't do it defense. Well, Mr. Prosecutor, that's a charge the jury gets about the lack of evidence in the case and things you didn't do that you should have done. What are you doing getting up there if you don't have anything that's going to improve your case? All you're doing is solidifying the bad parts of your case. Second, the defense is trying to discredit law enforcement. I think quite the contrary, Gene. She was basically very complimentary of law enforcement. She used them as the reason to believe that it was Eric because they testified to that. My last one is I'm not going to harp on this. I'm not going to harp on that. You know what you heard. Well, you know what? That means you have nothing to say. Mr. Rossi, I turn it over to you, sir.
That I'm going to try to go into my Zen mode because I was real hard about the openings. That was not a strong rebuttal for many reasons. It was tentative, it was meandering, and for the life of me, why they're continuing to pound this Dr. Hickerson, I mispronounced his name, versus the 9 people that heard Eric is beyond me. Here's what he should have done. The prosecutor, members of the jury, I want to spend a couple minutes on Dr. Hickerson and what the first responders said. Bam, bam, bam. Let's now talk about the incontrovertible facts. 1, why would a man who was innocent erase the text messages of a victim 3 days after the murder? Why? We all know why. Consciousness of guilt. 2, the cell phone tower records place him at the exact location at the exact time. 3, DNA. All those. He didn't do that. He spent 8 minutes on something that is ridiculous. I could go on, but I'm not. But I gotta say, here's the last thing.
You gotta hurry up, Gene.
Don't divide up a closing. The person who does the closing should do the rebuttal. Don't divide it up.
Yeah, listen. You know what? If that closing statement that you just gave for the prosecution was done in rebuttal, it would have been, in my opinion, far better than what we saw. And that's why, Gene Rossi, you are a guest on the Law and Crime Network. We'll be back at the other end of the break. This is the Jessica Chambers case. That's the interview, which was a substantial reliance by the prosecution in this case to bringing the charges against Mr. Tellis. I got Gene Rossi with me. Gene, we have a short period of time, but listen, you're sitting in there. He may be kind of a street guy in my mind. He's been around the block a little bit. He knows those cops are there and that he is a suspect, no doubt about that. And I found a very interesting tell that the cop did where he says, that's the day that you, and he stops, or she died. I mean, it was almost like the day you killed her. Let's talk a little bit about investigative bias and or when people think that they're the target, sometimes they lie.
Well, I can give you a good example of someone who lied in a death penalty case. In Illinois, two girls died. They were 9 years old. One was the daughter of the first victim. The police interviewed this man, the father of one of the deceased girls. He did a written and videoed confession. It's the George Torres case. And this father gave a false confession because the interrogators were so hard on him over 20 hours that he just succumbed. I got to compliment the investigators here. They showed a lot of professionalism in playing a little bit dumb, and they were very respectful, probably because they were on video. But they did a pretty good job. I got to say, I've seen some horrible interrogations. This one's not bad with what they have.
The guy that I worked with that I think is by far the best interrogator, I've mentioned him before, he was a tactical operations captain in my office when I was the prosecutor. He could get anyone to talk. In fact, Gene, he had the distinction of having a motion to throw out a statement in a murder case I tried as the prosecutor on the basis of he was too nice. I'm not even making that up, that he was too kind to the defendant and lulled him into giving the statement. But yes, but my point that he would always bring out to me is they may be lying and you know they're lying, but you got to figure out the motivation and reason for the lie and not jump to conclusions.
And can I add one thing? I don't know if the prosecutors in closing or the rebuttal, the Big Mike story is huge. And I think the prosecutor did the closing, said, I'm not going to go through the Big Mike story again. Are you kidding?
Yeah.
That is a huge, huge elephant in the room. Big Mike was a big fish story because he was guilty. That's what I would have did.
Gene, me and you are like brothers from another mother, or whatever you said in that tweet that one day.
We're brothers from another mother, and I would love to try a case with you.
Yeah, absolutely. I was just saying to Jonna Spilbor yesterday, Sunday, because we're covering it 24/7, that if now this trajectory of the case changed because they put a defense case on the Big Mike issue, I would have done what you said in summation, go to the reasons why you arrested him, and then go attack the defense case. You don't just sit there and say, well, you know about that, and throw it up. It's killing us, Gene. It's killing us. Let's go back to another clip of the interrogation, and we'll be on the other end. Okay, you know what that is? That are the gods at the Law and Crime Network that are saying, we need to hear more Bianchi and Rossi rather than that interview, because I think, personally, it's more entertaining, my personal view. Hey, Gene, you still there?
I'm always here.
Okay, my man. So we were talking before about, this particular issue of the statements, and you got to be really careful. And I just don't think that no matter how much this guy may have lied, prevaricated, or what have you, one, you got to figure out why, and two, you still got to get around the Eric issue. And many of the people in the chat room were kind of on your point that it just didn't make any sense to put on these experts to dispute what everyone knows is what happened. She didn't just mention him. She was answering questions, as well as the fact giving her name. These were law enforcement officers, EMS people. I mean, is the fact that he lied in his interview going to overwhelm that evidence?
Well, I'll tell you, your chat room people are very bright, and I love their comments from what you tell me. I got to say this. Whenever you have a chain around your neck, which is the Eric issue for the prosecution, the way to unlike that chain or to cut it in half is to focus on the facts that point towards guilt. And what really troubles me about the opening, the closing, and the rebuttal is obviously they spent too much time on that Eric thing, but they didn't spend enough time describing in detail. There's about 5 pieces of evidence that point towards guilt. I don't think I heard more than once or twice his DNA was on the chain, although the keychain, although the prosecutor did talk about that. But I would just use that as part of the timeline, the erasing of the text. Here's the other thing. Why the heck did they put on Sherry Flowers, who says that it was a 19-year-old kid who didn't smell like gasoline? I don't know why they put that person on. So there's a lot of things that they did that I won't agree to. But here's the bottom line, Bob, and you know this. When you have a murder case that is horrific, like this one, you can have holes in the prosecution's case, but juries want to find a person to blame.
Right.
Because there's a victim. And I know they're instructed it's beyond a reasonable doubt, but when I was a prosecutor, we used to kind of discuss how the burden of proof kind of is lowered a little bit subconsciously. They want to find a killer. And I'll tell you, it's probably 11-1, 10-2 for guilt. You know, that's why that dynamite charge, may not work.
Okay, well, I'm not too certain what the numbers of that's going to be, because I think that Derek Eric thing is a much more substantial thing than we think. You're at the Law and Crime Network. We're at the Jessica Chambers case. There's a lot going on. Could be a potential mistrial. I'm on with Gene Rossi. Stay tuned. We'll be right back. Thank you. Well, you're watching 2 law enforcement officers question in a lengthy interrogation of Quentin Tellis, who's on trial for a second time for the horrific arson homicide of Jessica Chambers. The jury's out at lunch. There you see the defendant there and the defense attorney to the right of your screen. They will be coming back. They have already indicated to the judge they could not come to a decision, and the judge basically told them go back in to see, after the infamous Allen charge, if you can come to a verdict in this case. I have Gene Rossi with me. Gene, just to move away from the statement, because we'll get into that, and we've listened to closing statements and we'll hear more about it. Interestingly, the judge in this case selected the foreperson. I don't remember the exact racial composition of the jury, but I believe it to have been more weighted towards African Americans or minority jurors, picked a white female to be the foreperson. My question to you, 1, have you seen judges pick 4 people before? And 2, why would he pick that particular person, if you know?
In my 30 years with the U.S. Department of Justice, in my cases and ones that obviously I was aware of, I have never seen a judge pick a foreperson for a jury. That's issue number 1. Number 2, why the judge picked, if it is true, a white female is beyond me, because you know what that judge has just created, Bob? An appellate issue if there is a conviction. And I got to tell you this could go to the United States Supreme Court if the judge picked a white person as the foreperson of the jury. This could go with Batson and the other case involving peremptory strikes. It was a very stupid move, in my view, with all due respect to the judge. Very stupid move. You know,
Interestingly, just so our audience knows this, is that when the judge gives the charge to the jury, if you will, he basically says the foreperson has no more power over deliberations or voting than you do. It's more of an administrative position. But I agree with you, Gene. I have never seen the judge actually select the foreperson as opposed to randomly. We used to do it through the balls, or, there's now a random computer process that would actually is supposed to pick a random person. So it is peculiar, and yet this judge was very good in this trial. It seemed very squared away to me. I'll just give one more opportunity to ask you. I mean, can you, for a guy who's pretty experienced, it seemed to run a good trial and made sure the trains ran on time, can you speculate as to why he would do this?
He made an unforced error. Roger Federer is the best tennis player of all time. He makes unforced errors. This was an unforced error. Now, in his defense, it could be possible, Bob, that the jury asked the judge to intervene in selecting a jury. But when he picks a white female as a foreperson in Panola County, Mississippi, you're just reinforcing the view of many in that community that the system is weighted towards other people of color. And it just was not a smart move.
Yeah, Gene, I have to think from watching this judge, and I've seen a lot of judges that are kind of yahoos out there, but this guy doesn't strike me as that. So I'm going to actually ask our Kathy Russin, maybe she has some more insight into this, because I think we're missing something. But the people in the chat room are asking this, and it's a very legitimate question, and if it was not agreed to by the prosecution and defense, or if there was any argument over it and he did this, yeah, it could be a problem, and certainly optics-wise, it doesn't look good. Anyway, we got more with Gene Rossi, and first we're going to go back to a little bit more of that interview, and we'll talk to Gene on the other end of that. The jurors are at lunch. There's a potential motion that's going to be heard with regard to somebody taking a picture, supposedly from the Tillis family, of the jurors and putting it on social media. We got a lot going on. We've been covering this gavel to gavel, stem to stern. Hey, Gene, I like to say it's murder, mayhem, a Motivation Monday here at the Law and Crime Network. We'll be back. Okay, welcome back. That was one of the fire personnel. I have Gene Rossi with me. Now, Gene, I feel like we're beating a dead horse here, but I mean, to the point that some people are of the belief, and that's fine, that she may not know what she was saying and she was out of it. Here you got yet another guy, not necessarily in my mind the most sophisticated person, certainly not somebody who's going to lie, somebody who's always on team law enforcement and saving and rescuing people, to say she's responding to a question, what happened? Someone set me on fire. I mean, it's not like she was just completely out of it. You could give me all the experts about burnt throats and burnt tongues, and it's an impossibility, but you got 9 people saying, guess what, Doc? We were there and happened.
I do got to add this, though. In his opening, he talked about the experts going to say she couldn't talk. And I think this was their first witness, or one of the first witnesses. And he quotes her as saying, I'm going to die, Jessica Chambers.
Yeah.
And so the first witness just made his opening seem irrelevant.
Okay.
Hey, minor point.
No, it's a major point.
I'm joking on that. I'm joking.
Yeah, we're beating this dead horse. But listen, Gene, let's get into the fact there's a note. The Allen charge was given. You aptly described what that was. This jury was unable to come to a decision. It's lunch. Talk about the mystery. I could be wrong, but let's talk about the mythology of the after lunch note.
Right. In my experience, my own trials and supervising, jurors love to have lunch, and I have seen many a verdict, whether it's hung, acquittal, or conviction, occur within 45 minutes of the juries receiving their lunch. And here's the other thing. Jurors are looking at their watch, and they know that if they get a verdict by about this time, Mississippi's an hour behind, so it's about 1 o'clock Mississippi time. I've been there many times. They're thinking, okay, if we get a verdict today or a hung, I'm going to be home tonight. I won't have to stay at a hotel. They are thinking about that. Trust me, Bob, you know the same thing.
Yeah, absolutely. I mean, we could be wrong. They could be asking for the definition of reasonable doubt, which is another killer in situations like this. But listen, I tried a case where they had hundreds of thousands of dollars in meal bills in a death penalty case, and still waited for that last lunch before they came back to verdict. Guys, we are all over the place. Got Gene Rossi, no better guy to be here for that activity going on in court. We're going to go to a break. We'll come back on the other end with more Law and Crime in the Jessica Chambers case. Okay, well, that's one of 3 defense witnesses, Mr. Misters. Gene Rossi, you're with us here. One of our chat room people brought up an interesting point. I just want to jump back a little bit about the injury, and I thought of this myself, but I wasn't confident enough in having watched the whole trial how accurate it is. But this thing about they couldn't speak or she couldn't speak because her tongue and her throat were injured. And I was wondering this, but the allegation, at least in the chat room, is that this was reviewed hours after this fire, and her body may have been in a much different medical state at that point in time than it was when the first responders were there. I think that's a pretty valid point.
Absolutely. And I'm kind of surprised that the defense did not put on an expert to counter Dr. Hendrickson. I got to tell you, if you have an expert against an expert, that by itself is reasonable doubt. I've had trials where I put on this beautiful expert, and the defense put on an expert, not as good, I thought, but it raised some kind of reasonable doubt. And it could have been decomposition of the body. It goes back to she spoke, she walked, she talked. We're beating a dead horse. I did want to comment on this Mr. thing.
Well, just before you go there, Gene, and we're having a little hard time with your audio, but before you go there, I just want to say a JS fan also said what you said. It was interesting they didn't get a defense expert. So you got to, props to our people in the chat room because that is a really, really powerful point. I'm sorry, you want to make a point.
Oh, is it George Mister who just testified? Is that the person?
Yes, Mister.
I kind of thought he was a good witness. What I'm gathering is that the defense is trying to plant a seed that the police are just putting out this fishnet, trying to find anybody because it's a horrific murder. They don't have any confession. They don't have any real DNA, and they're grabbing for straws. And I think that's the purpose of that witness, and I thought that was pretty good.
Well, that was the second of three of the witnesses. I'm not certain whether we're going to get a clip of the first witness. I know we saw it earlier today, but this was, and hopefully we do have an opportunity. I thought it was the most powerful of the defense witnesses is a jailer that works in that county sheriff's department who was going by and making a 911 call having seen the fire, and she just coincidentally happens to have a son named Eric, of all things. And when the cops are doing their due diligence in terms of the investigation, they find this 911 call, apparently take a run at her. I mean, it's a person who's never been in trouble before, works for the sheriff, then winds up going to the school where her son Eric is, and starts kind of dressing him down, if you will, a little bit, which goes, I thought was very effective for the defense to say the police completely believed that the victim in the case said the words Eric, and that's why they're going after a poor random kid whose mom works for the sheriff's department.
Absolutely. I totally agree with that. Totally agree.
And I hope we get an opportunity, to also talk about that third witness. In fact, I'd like to, and I ask the producer if we get to that third clip perhaps at some point in time, because that is one where I felt that the first two, we just saw Mr. as well as the female mom whose son was named Eric and works for the sheriff's department, were pretty effective to that point. The third witness, I wasn't so sure, and if I were the prosecutor, I would have stopped trying to justify Eric Derrick. I would have stated the reasons, as you indicated, as to why we brought the charges, and then I would have hammered on that third witness, who I think pretty clearly was either at a minimum highly inaccurate, if not untruthful. So let's go to one of those clips, and Gene, we'll talk to you about it on the other end. Okay, so Gene, this is a witness that knows her. I want to go back to the three defense witnesses in the case that I think painted the mosaic, the first two being better for the defense as opposed to the third one, who clearly at a minimum was highly inaccurate and went to the alibi in the case. I really didn't hear the prosecutor banging up on that. I mean, do you find that would have been a safe haven for them to stop talking about Eric, and really hitting on a witness that obviously they did a good job crossing her into the lies?
Yes. And what you say in closing, and Bob, you are a prosecutor, of course, when a defense puts on a case, and they don't have to, but when they put on a case, the jury has the right to judge it just like your case. And if they put on a witness that is trying to have a red herring or is disingenuous in what they say, you have to hammer that, because then you're not legally shifting the burden, but it says, hey, that defense was kind of shady.
Right.
Let's now look at the prosecution's case again, because the defense was kind of shady, even though they didn't have to put on a case.
Yeah.
I used to love
Absolutely, Gene. I'm sorry to interrupt you, my man, but we do have to take a couple of breaks here at the Law&Crime Network. I love your commentary. Thank you very much. We're in the Jessica Chambers case. The jury sent a note out. They're not necessarily, they may be deadlocked. We'll be back. All right, welcome back. We're in the Jessica Chambers case, and look, this is serious. It's a horrible case. I got Gene Rossi. I want to thank my friend Gene Rossi for his commentary, because he was supposed to go at 2 o'clock, but he wants to go to 3 o'clock when my shift ends, because we got this note from the jury, and everyone in the chat room, to our little internal circuit, nail-biting emojis and things of that nature. But apparently, listen, this is where we try to predict what a jury's thinking, what a jury's doing or not. Apparently, the note was about this. they all want to get something for lunch and put their lunch order in. And so there we were, running around like crazy, all concerned, but we all got to eat. So does this jury. That's what that note apparently was about. But listen, we are on the verge, the precipice. It could actually happen in this next hour because Gene Rossi, as you know, they brought back a note to the judge that said, we can't finalize a verdict here. We don't think we can come to a conclusion. The judge gave the Allen charge. Could you just do me a favor briefly, re-explain to the audience what the Allen charge means and how far can the judge go if they come back with another note that says we can't reach a unanimous verdict?
An Allen charge, that could be grounds for appeal. What is an Allen charge? They call it a dynamite charge. And basically the judge is telling the jury, okay, folks, we know you're split. Please go back in that room and reevaluate your position, and also please listen to the persons with the other view and try to come to a resolution for the following reasons. This is an important case to the defendant, to the government, and to the public. A lot of resources have been expended, so do the best you can because we need a decision from you. And I'm not telling you which way to go, but give it one more college try. And usually you do a dynamite charge after you get 2 juror notes that say we're hung. Sometimes they do it after 1. But if they give a second dynamite Allen charge, that could be a grounds for an appeal if there's a conviction.
That is an excellent description, and I know I could just do that with you right off the top because you trained over 1,000 lawyers and tried many cases, in addition to the fact that you can shoot 40 and 41 points in a state championship team is why you are the man. Spot on. And, you know, interestingly, the judge will also tell them so long as you're not doing violence to your judgment, which is always kind of, I think, a confusing terminology to the jury. But listen, the prosecutor's closing. We've been talking a lot about this. Gene and myself have been kind of maybe taking a lot of hits. We try not to do that, but let's go back to the closing statement and watch how the prosecutor tried to kind of cross their arms and kind of slunched over, thread a needle here to get past damning testimony that his own witnesses gave about the victim saying the perpetrator was either Derek or Eric. Let's get to it. Okay, that's Jessica Chambers, prosecutor's closing statement, trying to thread that needle there, trying to get around evidence that was very powerfully presented by the defense in this case. Gene Rossi is going to stick with me. We know that the jury is deliberating right now and having a difficult time coming to a decision. Before I get to the prosecutor's closing, one of the tech guys in the Law&Crime Network, you got to understand something, Gene, what's going on in this place. You got writers, you got tech people, you got producers, you got all sorts of players. It always, every now and again in my ear, asks a legal question, and I've never heard this. I think it's really perceptive. Maybe you can answer it. I mean, I know the legal answer to it, but I think he kind of maybe presents a better way of doing things. So the audience understands in order to get a unanimous verdict, you have to have 12 guilty or 12 not guilty. Anything that is a split with people saying guilty and not guilty is what we call a hung jury or creates a mistrial. And the question that Eddie, my man, is asking is if you're presumed innocent and you go to trial and the state can't prove its case beyond a reasonable doubt to 12 jurors, why should you be tried again? I think it's a perceptive question.
You mean if it's a hung jury?
Yeah, in other words, if you get a crack at this guy got a crack before, let's say he gets a second crack now, he can't come up with 12 people. I mean, it kind of goes to the point, like, can they try Quentin Tellis 49 and 52 times and just keep twisting the defendants in these cases? Why, if the state has to prove a case beyond a reasonable doubt and you're presumed innocent, if they can't meet that burden in one trial because it's a split verdict, why is it tried a second time?
I'll give you one answer. The Supreme Court of the United States has addressed that issue, and it's basically said, with limitations probably, that a hung jury means it does not violate the double jeopardy clause of the Constitution that applies to both the federal government and the state government. And you can try a person again unless the prosecution did something to cause the mistrial. If that's the case, then the double jeopardy clause would prohibit it.
Yeah, we know legally that is the obviously on-the-money answer, but I guess I'm getting into more philosophical space in my mind as to, It kind of makes a little bit of sense there. Well, you got a shot to go after the guy. You couldn't do it, and therefore he should be let off the hook. Now, we know that's not the law. But, you know, one last point I want to bring up with you, Gene, is, you know, twisting through the Supreme Court right now is the dual sovereignty doctrine as to whether or not you can be charged for state and federal crimes for the same offense. Let's just take a little bit of a sidebar here, because we've been watching a lot of this trial. If anything happens, we're going to jump into that courtroom. We'll get back to more clips, but talk about that if you can with us.
Absolutely. For your audience, there are 50 states, of course, and then there's the federal government. The Supreme Court has said, for purposes of the double jeopardy clause, if a person is acquitted in Alabama, he still can be tried federally for the same crime because they're two different sovereigns. If a person is tried in Alabama and he's acquitted, and he can be tried in Mississippi for the same crime, say it's conspiracy to commit murder, because Mississippi and Alabama are two different sovereigns. And as you said, before the Supreme Court in October, there's a case that wants to get rid of that dual sovereignty doctrine, they call it.
Yeah, and if I understand, and we just work on that audio a little bit there, Gene, if I understand it, actually, Senator Orrin Hatch wrote a 40-page amicus brief with respect to this, and this could substantially weaken, actually, prosecutors' cases, because I can tell you as a defense lawyer, when you get the pile on of both state and federal charges, you're fighting a two-front war, and it makes it very difficult. So what are your thoughts about the fact that, you know, I wouldn't suspect that Senator Hatch would be one of those people who would be against this dual sovereignty argument?
You know what? My view is this. If someone beats a murder rap or any kind of charge at the state level, I do think it's unfair to allow the federal government to bring that same charge for the same crime. I think the dual sovereignty doctrine, it troubles me. It does trouble me.
Yeah, I agree with you, and you got to kind of be practicing. I mean, even as a prosecutor, I felt that, listen, you either, let's say a bank robbery case, that could be a state crime of armed robbery, and it could be a federal crime for bank robbery. I was not a fan of doing parallel prosecutions and charging. Let one jurisdiction handle it. If the feds don't want it on the bank robbery side, we'll take it. You know, these sentences are extremely significant to begin with, and I just felt it was fundamentally unfair to make somebody have to go to two jurisdictions to try the same set of facts, the same day, the same incident.
Bob, I will say this. If you have a person who's killed multiple people, I tried a murder case once. The defendant killed 35 people. We could only find one to prove. If you got a person who is acquitted at the state level and you have federal charges for that serial killer, I don't have a problem with federally trying him again, even though he may be acquitted at the state level.
Yeah, you know, fair enough, Gene, and I agree with you with that. And sometimes the tools with the gangs, the violent gangs, the career criminals, the people who are really representing a danger to the community, I completely agree those tools were available and it's good. But I got to be honest with you, Gene, what is your opinion about the fact, since I've been practicing law, we've gone from such a place of mandatory sentencing, periods of parole ineligibility, hitting flies with sledgehammers, people charged with minor offenses, let's say a minor drug offense, it's charged in federal and state court, or a sex offense charged in state and federal court. The big players, the big crimes, the big public interest cases I get, but don't you find a lot of small fish are getting caught in that net?
Absolutely. And here's a statistic that just blows my mind. We have 5% of the world's population, but we have 25% of the world's prison population. We need to take a smarter approach to our criminal justice system and not kill a fly with a bazooka. And I'm really big on the opioid crisis, and there are a lot of people who are addicted, overcome by addiction. And I think the criminal justice system, you know, addiction is a disease, and we shouldn't treat it like it's a violent crime, and we should be more compassionate in how we treat people, especially when it comes to addiction.
You know, one of my worst days as the prosecutor, Gene, and you know very rarely does the prosecutor go up into court and argue is when we had a 5-year period of parole and eligibility for and a law enforcement officer who got hurt on the job and then got addicted to drugs, and he got charged with official misconduct. And I got up there to say that even though we got to give him this sentence, I think it's a disgrace what we're doing with this mandatory sentencing, tough on crime. He didn't deserve to be in jail for that period of time, but our hands were tied. Guys, we hear there is action in the courtroom. Now, you know, it's more than inaction, and it's less than a verdict. We're somewhere in the middle. But Kathy Russin is there, so you know we're going to get it quicker than anyone else in the entire legal community and news community, because Kathy is on fire. Get into that chat room. You were in the Jessica Chambers case. Thank you, Greg Rossi, for sticking with me to the 3 o'clock period. We hope one way or the other the jury comes back so that I can be on here with you and break it down. It's a fascinating, horrible case. And we are going to be back on the other end of the break, which should be coming to you right now. Okay, welcome back. So we got so much going on here right now. I got Gene Rossi to help me out and carry me, swaddle me like a swaddling baby through the courses and vicissitudes of what's going on here in the Jessica Chambers case. Hey, Gene, I just want to hit you with one thing. I hope I get it right with our chatters. Sometimes it's difficult for me to see even with my glasses on. But Laura Lux asked the question because based on the fact that she sees in the chat room, if you want to know ahead of time what's going on, go to the chat room because Kathy Russin's in there. And apparently the jury wants to review the evidence, and the judge is closing the courtroom so we don't have a live feed of this. And we don't know right now if it's a specific piece of evidence or what evidence is. And Laura Lux asked, why are they reviewing the evidence now? And since we have some time, rather than going over all of these clips that we've gone over before, which I love doing, but these kind of questions in the chat room give us an opportunity to speak to things that we normally don't get an opportunity. Maybe you can explain how it is that evidence gets introduced and when it is and when it is not that a jury is allowed to have an opportunity to review that evidence during deliberations.
Right. During a trial, the prosecution is allowed to introduce testimonial evidence under oath, of course, documents, demonstrative aids. And depending on the judge, all that goes to the jury, including charts that are demonstrative aids, summaries of exhibits. As a prosecutor, I was scared to death whenever a jury wanted testimony read back to them, or they wanted to re-look at documents. Well, they already had them, but when they wanted basically testimony read back to them, here's why. That suggests to me that something the defense attorney said in her closing, or something the prosecutor said in his closing, was not right in the jury's mind. And I never saw an indication where they asked for testimony to be replayed, if you will, because it was going to help the government. It usually was going to help the defense.
Yeah, well, I'm sorry to cut you off. I agree with you. In most instances, if the jury needs to go back and start reviewing things copiously, that could be a sign when the prosecution has the burden of proving the case that there could be a problem. I've always found, too, Gene, when you get the question, can you define reasonable doubt, 80% of the time, that's not a good prosecution question because it shows at least somebody's got some doubt that be having that read back. But we also have one further question from our chat room people, Nicole Curry, who asks, will the jury get transcripts, too, or just actual evidence?
Okay. They will get probably the testimony read back to them. I don't think they'll get the transcript because I don't know if they have daily copy. The court reporter may not have it. But I want to stress, Bob, that a judge has unlimited discretion to say, yes, we're going to read back the testimony or not. And also the judge has discretion to say, oh, you want a transcript? I'll give it to you. I've never seen the transcript given back. I've seen reading of the testimony. reading of the testimony.
Yeah, I agree with you, Gene. Actually, I've never seen it. In fact, I've seen the court actually say, no, we will not do that. If you have a specific question about the testimony, let us know what that is. We'll give readback. And the reason for that, Gene, is that they don't like to put a transcript in or just a statement or an audio recording is because they're afraid the jury is going to be over focusing on that one particular piece of evidence when it's their job to look at all the evidence. So to answer the question from our chat room person, I would highly doubt that they would just throw a transcript of a witness into the jury room. Although, Gene, I think that me and you have both lamented before around this country, we've seen some pretty wild stuff happening in these courtrooms.
I've never seen a judge read back testimony. I've never seen it in my case.
Read back testimony?
Yeah, have a witness get on the stand and read a transcript that the jury wants read back.
Yeah, the way we do it, maybe it's a little different out there, is that if the jury said that we would like to have the testimony of witness X, is that the court reporter or the clerk, the judge would try to narrow it down, of course, would actually read the transcript. It wouldn't be like an actual witness. It would be, I think you're referring to the Liggins case where they had the actors essentially portraying the trial through reading the transcripts?
Yes.
Yeah, that was quite.
But Bob, what they could do is just get a deputy clerk to sit in the witness box.
Yeah.
And then, but you're right, the court reporter sometimes does it, but sometimes you don't have a court reporter with a very good, voice, if you will.
Yeah.
So they may have somebody else do it.
I remember actually, Gene, just to bat around some old stories here, I think that our viewers would be interested in, is that there was a read back in the old days of a murder case I had, and the court reporter was being very inflective with her voice. A flat transcript, a cold transcript is one thing, but when you have a live witness testifying, it's something completely different. And I was amazed at the skill of this court reporter because she was actually getting the inflections of the witnesses, which is a real art form. But the defense objected to her inflections, and it caused the jury to be cleared from the jury room. And we had a big argument about whether or not she should just read it word for word in a monotone voice, or whether she should use those inflections. Did you ever have anything like that?
No, but I did have an interpreter that was magnificent and did pretty good inflections. Never had an objection on that grounds.
Wow. I love talking about these stories, Gene, and I appreciate it. But we're in the Jessica Chambers case. Thank you for sticking with us an extra hour than you were scheduled to do. You're a phenomenal guest. I'm always ecstatic when I open up the spreadsheet and I see your name is there as my guest, because it's not only helpful to me, I learn as well. And the chat room people, thank you for your questions. I'm going to try to go back there. We're going to look at a quick clip. Get in there for the chatters. Please ask the questions. I'll look at them right now when we do the clip. I'll come on the other end. The jury right now is reviewing evidence. We don't know exactly what right now. Kathy Russin is out there. Court is closed while they're reviewing that evidence. Right now, they've indicated that they are in a deadlock, that they don't have a decision. The judge sent them back under the Allen charge, as Gene aptly described what that is. And apparently, they're trying to give it another yeoman's attempt at coming to a verdict. Law&Crime Network, gavel-to-gavel coverage. We'll be right back after the clip. Okay, this is the Jessica Chambers case. That is the closing argument of the defense attorney. Did a very good job. I got Gene Rossi with me. Gene, I got a tight time frame to get these 3 questions into you, or at least statements. Fun free on there, kind of consistent with in the chat room, kind of consistent with what we talked about before. Wants to know whether they can get the cell phone data records. And again, I think it goes back to the same thing with respect to if it's admitted into evidence, the judge can give them that data if they want, but it'll pull it out once they've had an opportunity to review. Thoughts?
It should be available to the jury. It should be in a jury room.
Right. That's anything in evidence can be everything in evidence is there.
Yes.
Right. Okay, listen, HJ1 Mad City says that if this is a hung jury and they're going to try it again, they should get a special prosecutor. I'm available. What about you?
Yes, and I'll be your second chair.
Oh, no. Well, we'll have to debate that. We'll just pull straws on that one because you are the man. Anon3433 wants to know, why not more of the prosecution about the burns, the real the real, I mean that way, but, the real harsh stuff, the stuff that really viscerally impacts the jury. What are your thoughts on that?
You mean the burns on the victim or on him?
On the victim.
Well, I thought they put in photos of the victim and also described that 98% or 95% of her body was a third-degree burn where the skin is basically ripped off. I thought they got that information in. I don't know if be a need to bring out more evidence on that.
I want to talk to you a little bit about those photos. In an arson homicide that I had that were literally the burns of gasoline, 98% of the body, they were really, really bad. We had both the crime scene photos, the photos. She had been treating for a number of weeks, actually, before she succumbed to sepsis from this that kind of injury, the breeding that they would do during this. We argued that it was relevant to show the manner and mechanism of death. The defense was arguing that they're too gruesome, that the probative values outweighed by the awesomely prejudicial effect. Have you ever had this argument made, and would you agree? Would you have made that argument as a defense lawyer in this case?
Yes, under Federal Rule of Evidence 403, relevant evidence can be excluded if it's unduly prejudicial. Every bit of evidence put on by a prosecutor introduced is prejudicial. Is it unduly? And let's just say the government wanted to put in 10 photos of the knife going through the throat of the victim. A judge may say, you know what, I'm only going to let you put in one. You don't need 10. So that's probably what would happen here. He probably let in a limited amount of photos of the victim, but not an overwhelming.
Yep, and that's usually the way they do it. I love it. You know 403, 404, 406. Guys, you know what he's talking about? The evidence rules. And if you don't know them cold, stone cold, then you can't be as effective a trial lawyer as you should be. They are literally the Bible, because if you can't get the evidence in, then you can't win your cases. That's why we love having Gene Rossi. We got to go to a break. On the other end, we'll come back with more Law and Crime. I know Aaron Keller's getting ready to get going here. I'll be hosting at 3 o'clock with Gene, so we'll go to break, and we'll be back on the other end. Okay, guys, welcome back. This is the Jessica Chambers case. I'm here with Gene Rossi. The jury is right now looking at reviewing evidence after they were given the Allen charge, and Gene Rossi explained what that is. So they are going and giving the Yo person's effort to go back there, reevaluate the evidence to see if they can come to a conclusion, a consensus, unanimity, without doing quote-unquote violence to their judgment. And that's what they're doing right now. We have Kathy Russin that's at the scene of that courthouse. She has been reporting back to us on a moment-by-moment basis. It's right here on my computer. Gene, we've been given an opportunity by our producers to talk a little bit about trial strategies. I've been asking the people in the chat room. I have a complete open portal right now to ask them to ask any questions they want. They've been asking killer questions. But I want to talk about something that goes on that's beyond the actual facts and law and verdict in this case. I want to talk about lawyer psychology and the emotions that are happening right now for the prosecutor and the defense lawyers as they're sitting there with nothing left to do other than waiting for this decision, how they're looking at every juror's face when they come out, how they're evaluating the questions, wondering what's happening. Tell the jurors how intense this is for us as trial lawyers.
I'll give you one of my trials. I prosecuted a pain doctor. Bob, the jury deliberated 7 straight business days, Thursday, Friday, Monday through Friday. Verdict came back that second Friday at 4:30 p.m. During that period, including the weekend when they weren't deliberating, I had a knot in my stomach and a Rolaids problem 24/7. I couldn't sleep. I could barely eat. I was shaking. It is an incredibly stressful period, and I was the prosecutor who thought I put on a pretty good case. I can't imagine what it's like for a defense attorney. It's the most horrible part of a trial is after you've rested to the closings, and now you're waiting for the jury to come back. And let's go to a verdict. When a verdict comes out, Bob, I have never had anything less than this. My heart is almost leaving my chest because when that juror, 4-person, reads the verdict or the deputy clerk reads the verdict, my heart is actually exploding and I can see my shirt move. Even when I had a strong case, and of course I've had my share of acquittals. It's stressful.
Well, you know, Gene, I want to tell a personal story to our viewers. I'm here twice a week or whatever, but, you know, I was of the opinion that all these guys got up there and it was such an easy thing to do. My dad did it. I watched him. I watched lots of people as I was growing up. When I had to try my first jury trial, on the opening statement, I was so panicked. I couldn't believe this, that my heart was beating so loud, I couldn't even hear myself talk. And if you know the way I modulate, you know that's quite a feat. And I was wondering to myself, the only thing is I was speaking, was kind of like an out-of-body experience. I was wondering is how I wasn't passing out. And then afterwards, I didn't remember even what it was I said. The judge complimented me on giving an excellent opening statement. The point of that story is I had to learn to wrestle many years with this fear and anxiety with respect to trying cases because I love doing it. And when you get on the other end of it and you win a case, I would imagine it's kind of like what a rock star feels like when they're done with their final set and they're getting an applause. It's an addictive kind of thing, too. It's weird. It's intense.
It is. And also, Bob, I called it postpartum depression. When you have a verdict of guilty or not guilty after a long, stressful trial, the next 5 to 10 days, maybe 2 weeks, my body actually goes into postpartum depression because my adrenaline was so high for several weeks, if not months. And then you don't have the stress or the burden of preparing for a trial. And you're thinking, what am I going to do now? And I always used to like when I had a trial, I got a verdict, and then the next week I had another one. I always liked that.
You know, when I was a baby prosecutor, we were lucky. I mean, they couldn't even find people that wanted to be prosecutors. And I was like, give me whatever trial you want. You try ad seriatim, one after another. I had two juries deliberating at one time, picking a jury on another case. And you're right, that keeps you really focused. But when you have a break, your whole body like catches up with you. You get sick, you get a cold, you're run down. But, you know, Gene, one question I have for you. Openings were always my more nerve-wracking scenario as opposed to summations. Once all the evidence was in, I found I was far more comfortable in the summation, I guess because the road has been traveled. How about you? Do you feel the same way?
Yeah, yes. Openings are stressful, though. You know, towards the end of my career, I felt a little more comfortable. Closings I loved. And here's why, Bob. You bond. If you don't do this during a trial, I always tried to bond with the jury. You know, you can't talk to them, but there was this subliminal, connection that I made with the jury. You become familiar with them. They look at you. They kind of smile sometimes. And then in a closing, you have so much more flexibility. You are telling the jury what they heard, not what they're going to hear.
Right.
And you can draw conclusions from what the evidence presented, what the jury can conclude from the evidence. It's a beautiful thing. And rebuttal, as you know, Bob, rebuttal, which is the last word, is the most beautiful and powerful tool of any prosecutor, federal or state.
Right. You know, Gene, I'm actually going to go to one of your latter points, writing a book right now on the parallels about fear and anxiety, about trying cases and how it can translate into your personal life. Because I agree with you, once you've gone down the road and you're no longer worried and anxious about what your witnesses are going to say or not say, you feel much freer, you've built a relationship with the jury, and sometimes you just got to let go and let it rip. And I was always a very forceful lawyer, but I would always teach when I got older, I would always teach my young assistant prosecutors that, you know, it's okay to be nervous. It's okay to be fearful. Just don't back down. Get into that arena. Fight the good fight. Fight honorably. And whatever the verdict is, it's going to be. So now, unfortunately, we're going to have to take a real quick break here at the Law&Crime Network. We are in the Jessica Chambers case. The jury's reviewing evidence. I got Gene Rossi with me. And thank you all for the opportunity to be able to speak to you about the emotional side of what trial lawyering is like, because it is intense. We'll be back on the other end of the break.